2021 is now in session.
Please be seated. Good morning. We're here for our oral argument in our case number CV24-0298, Accursio versus Treehouse et al. Council, remind you we are recording and live streaming the argument, so please identify yourselves and your client at the beginning of your argument. Each side will have 20 minutes. You're not obligated to use all that time. Appellant's counsel, if you'll watch the clock and reserve as much time as you wish for rebuttal. Also, please keep in mind we've read the briefs, we've studied the record, and have discussed the case in conference. So, and with that, counsel, for appellant, you may proceed.
Good morning, Your Honors. Kyle O'Dwyer of Fortified Legal Services representing the appellant John Accursio. Your Honors, this morning we're discussing three issues that have been identified by the parties. Whether the complaint contained allegations sufficient to state a claim for wrongful institution of civil proceedings and aiding and abetting that claim. When the claim alleged that a bar charge was filed with the Arizona State Bar against appellant in order to retaliate against appellant or as a course of conduct to refuse to provide documents to appellant's sister, and the bar charge proceeded past a screening and into investigation resulting in a number of different processes. Second, essentially whether Rule 48L of the Arizona Rules of Supreme Court precludes any such claim for wrongful institution of civil proceedings. And then third, whether the trial court correctly dismissed count 20, finding that the charge was dismissed prior to a proceeding, which is in large part enveloped in the first issue. Your Honors, I'd like to...
What does the record show about the substance of the bar charge? What was the conduct that Mr. Accursio did that allegedly constituted the unauthorized practice of law?
Thank you, Your Honor. The conduct that was alleged was that he improperly engaged with local counsel because he had local counsel that he had engaged with, and whether he had local counsel was rubber stamping things. And so that was the allegations. Now the substance of those allegations, I think the parties agree, are precluded from being a basis for wrongful institution of civil proceedings, because these claims have to be based on the conduct of the parties. Rule 48L does provide, and the Goldman case does clearly state as precedential authority, that the specific substantive allegations can't be the basis for the claim. It has to be conduct, which in this case was that this was filed in retaliation, and that the bar charge was filed in order to get litigation advantages in ongoing litigation and or pending litigation. And so that definitely goes to the second issue, which was raised by appellee, and I believe Goldman is precedential on that matter. It substantively delved into the facts in that case, into Rule 48L, and decided the substance of the bar charge cannot be the basis for a wrongful institution of civil proceedings, or in that case, abuse of process, but the conduct involved can, filing the bar charge and the conduct outside of it. And so because Goldman decided that issue, this court doesn't need to revisit it. It's precedential authority, it's decided. And the same thing for the argument that under Rule 48A of the Arizona Rules of Supreme Court, that states that a bar charge is neither, a disciplinary matter is neither civil or criminal. Goldman discussed that as well, deciding that, well, that is not a exclusive or preclusive effect. It's not that it is neither civil nor criminal, but it's inclusive in that it contains elements of both. And so, again, Goldman decided that issue, and so to the extent that it's raised, it is precedential for this court today. But I think the biggest issue and the more in-depth issue is whether or not this constituted a proceeding. What happened in this case? Because Goldman, it has some value in that it discusses a proceeding, but the court needs to view it in light of the claims that were at issue there, which was abuse of process. In an abuse of process claim, it is whether or not there was a judicial proceeding, not whether there was a civil proceeding, but whether it was judicial in nature. And I think that that's one of the important issues that the Goldman Court recognized. The Superior Court also latched onto this analogy of a prosecutor receiving a criminal complaint from a citizen. And that in the Goldman case, which is, again, looking at a judicial process, the filing of a police report, a criminal report, and considering it by the prosecutor isn't a judicial process, the court decided. Here, the question is whether it was in part a civil proceeding. And so they are very different. Whether it's judicial is very different than whether it is civil at all.
What was the proceeding here?
Here, the proceeding was the investigative proceeding that went under Rule 55B of the Arizona Rules of Supreme Court.
Was that the right rule that the State Bar referenced?
In looking at the rules a little more in depth, there is a rule that indicates, I don't recall the exact rule, that the State Bar could elect to go under Rule 78 or Rule 55 in their investigation. So it appears that they decided to go under Rule 55, even though Rule 78 is specifically applicable to, and only applicable to, unauthorized practice of law.
So why shouldn't that Rule 78 have applied? Why shouldn't it be applied exclusively?
All I know, Your Honors, is that there's a rule that allows them to decide which one to use. And so they made that decision to use Rule 55. And so there are some differences between the rules under 55 and 78. There are some significant differences. But my client would argue there is a proceeding under Rule 55 as well. Now again, turning to Goldman, which a lot of...
What was the proceeding?
Sure. The proceeding was the investigative proceeding that was commenced by Senior Bar Counsel Jim Lee. So proceeding, the Rule 55 talks about the initiation of proceedings. And a proceeding, my clients would argue, isn't only pigeonholed into a court case, which the rules, or a formal proceeding under the state bars. So Rule 55A is an initial screen. Someone from the state bar takes a complaint. No response is required by the respondent. They can dismiss it. They can proceed with it. They can ask questions. There are no rights to respond to that before it takes to the next step. That's where Goldman was just that initial 55A. It got summarily dismissed. In our case, it proceeded to Rule 55B, where Mr. Lee wrote a letter to my client indicating that, and this is EIR 59, Exhibit F, requesting a response from him. And importantly, the letter also states, you have a duty to cooperate with this investigation. Failure to fully and honestly respond to or cooperate with it is itself grounds for discipline. There were also a number of other procedures within this 55B proceeding that show that it's more than just a police report. It's an actual proceeding because, so number one, he has to respond or be disciplined. If he doesn't respond, the bar has the right to subpoena him to a deposition, to subpoena documents. If he doesn't provide those documentation, they're able to apply for him to be held in contempt of court with the presiding disciplinary law judge. So at this point, even though it's called a screening investigation with those significant procedural factors and the issue that he could be held in contempt of court, this should be deemed to be a proceeding. The other fact in our case was that Mr. Accursio applied for, he through the state bar, applied for a protective order because some of the information that he was providing would be deemed to be confidential or is confidential. And so the presiding judge issued a protective order allowing his response or prohibiting it from being fully provided and publicly available. So it was redacted in certain respects. And so because of all these procedural tools are in the bar's wheelhouse during this process, it is a full-blown proceeding and should be deemed to be sufficient to be a proceeding for the wrongful institution of civil proceedings.
What rule specifically are you relying on to say this was a proceeding? Is it 78 or is it 55?
I think we'd have to go to 55 just because
55 is what you're relying on.
that's correct. Because the bar letter does say 55B is what they decided to go with. And then also, it's also a proceeding under the restatement, Section 680, which the Goldman Court cited to in its opinion, which indicates that that an administrative disciplinary proceeding is a proceeding for purposes of wrongful institution of civil proceedings. The appellees want to make the argument that only formal proceedings are that where an actual complaint is filed within the disciplinary process are subject to a civil proceeding and a claim for wrongful institution of civil proceedings. But if you look at Restatement 680, it states that one who takes an active part in the initiation, continuation, or procurement of civil proceedings against another before an administrative board that has power to take action adversely affecting the legally protected interests of the other is subject to liability for any special harm caused. And so there it says, if the board has power to take action adversely affecting the legally protected interests of the other, it's subject to liability. At that point in 55B, they are able to take that action. They are able to come to an agreement on certain procedures that would be or an agreement on resolution rather than referring it up to the committee and the board. So at that point, under Rule 55B, with all the tools that the bar has at its disposal, and especially the ability to render a protective order, the ability to find and hold someone or apply to the court to hold one in contempt for failure to respond, that qualifies as a proceeding for purposes of wrongful institution of civil proceedings.
So we don't need to look at Rule 78A?
I think it should be applicable in these types of cases, but because the bar decided to go under 55B, that is the piece of the case that my client was subject to. Now, obviously, the bar could have. I don't see anything in the rules that says the bar couldn't transition the case to 78. And move the investigation under those bases, because under either, it's the unauthorized practice of law. In this case, the bar decided to go under 55, but Mr. Accursio was at any time, I believe, subjected to Rule 78 if the bar decided to go that way.
Was there a substantive difference in the procedures under Rule 78 or Rule 55? The Bar Council still has the same obligation, right? Do the screening, you can request information, you can issue subpoenas. The proceedings are the same regardless of which rule you go under. Isn't that the case?
They are similar. I don't recall exactly how they are different, and perhaps I'll address that in rebuttal comments. But I believe 78 has some additional procedural actions that the bar can take, given that it...
Like going to Superior Court and getting an injunction against the practice of law by someone who's not authorized to practice law, right?
I believe that's correct, Your Honor.
But in terms of the investigation, the procedures are the same, are they not?
I don't recall exactly if that's the case as I stand here, but I may address that a little more in rebuttal remarks. If there are no further questions, then I'll reserve the remainder of my time for rebuttal. Thank you.
May it please the Court. Good morning, Your Honors. My name is Chanel Risk. I represent the appellees Bianchi Brandt, Justin Brandt, Clark Wu, and Mukunda Shanbag. The crux of this appeal is when a bar charge, at what point in the disciplinary process does a bar charge then transition into a proceeding? And we're fortunate enough to have guidance from this court's precedent set in Goldman, where this court held that proceedings do not begin at the initial investigation phase of a bar charge. The Goldman case reiterates that Rule 46 and Rule 58A define a bar complaint differently than a bar charge. A bar complaint is that formal document prepared by bar counsel and filed with the disciplinary clerk initiating those disciplinary proceedings, versus a bar charge, which is any allegation that comes to the state bar under Rule 46. Now, I think what's imperative here to determine when a proceeding starts is to understand the different stages of the disciplinary process.
Well, can't we just look to Rule 78? Because 78A says, an unauthorized practice of law proceeding commences upon receipt by the state bar of a charge against a respondent. I mean, doesn't that answer the question?
No, Judge Kiley, it doesn't, because in this case, as Judge Fox said in the lower court, we have a letter from bar counsel stating that a screening investigation is being undertaken pursuant to Rule 55B. At this point, the matter is not considered a formal complaint, but rather a bar charge that's being investigated through a screening investigation.
So Mr. Accursio's cause of action against Mr. Wu depends on how the state bar decides to process the complaint, the charge. If they process it under Rule 78, Mr. Accursio gets to sue Mr. Wu. If they process it under Rule 55, Mr. Accursio has no right to sue Mr. Wu. Is that your position?
My position is that, that's basically correct, because under Rule 55B is where bar counsel has decided to put this investigation.
Why should Mr. Accursio's right to sue Mr. Wu depend on what the bar does, how they decide to process the case?
Because the bar is the authority here. The bar is processing it under Rule 55B, and those proceedings would not start at that point until they resemble that of a civil proceeding. And there's no characteristics here in this investigation process. There's just no characteristics of a proceeding. We all know that we need to file a complaint, file an answer, scheduling conferences, all those things that take place in the formal proceeding stage of this bar investigation. We just don't have that
We
here.
have a protective order. That's part of a proceeding.
The protective order doesn't really have anything to do with this. A protective order, Mr. Accursio requested that protective order to seal information in his response to the investigative questions regarding this case. It has, no complaint was filed, he wasn't filing an answer, none of those stages had been reached. This was simply to protect and seal information in his response to the investigator for this complaint.
The response makes this case different than Goldman, doesn't it?
You know, not so much, because in Goldman, we have a bar charge, and in that intake stage, the investigator can look at it and say, oh, okay, we're going to just dismiss it. They can also pick up the phone, they can write an email and say, you know, hey, complainant, here's the charge against you, or hey, respondent, here's the charge against you. Can you please go ahead and respond to this argument?
Well, they don't have to say please. They give us this information or else you're in big trouble, right?
Correct, but the same thing goes for the screening investigation. The screening investigation isn't much different. It's just basically a second pair of eyes looking at this, because if you look at the rules as to what can be done in the screening investigation, it's the same thing. We look at the complaint, we ask for a response, we ask for documents, we may have an interview if we feel like it. There's nothing substantially different between the screening investigation or the intake. It's just here, in this case, it's a difference of bar counsel reviewing versus senior bar counsel reviewing it. Neither of those reach the threshold of a civil proceeding. Neither of those contain the characteristics of a proceeding.
What would have had to happen that didn't happen here for a proceeding to have occurred under 55B?
The bar investigator would have had to recommend some type of discipline. The committee would have had to then ask the bar counsel to go ahead and prepare and file that complaint with the disciplinary clerk. Upon filing that complaint with the clerk of the court, that would have initiated the proceedings.
And what, is there something in the rule that's helping you get there, or something in Goldman, or?
There is,
It makes you say that's what would have to happen for a proceeding to start, to be initiated.
you give me one moment, Your Honor, I do have. It'd be Rule 47. And by a reading of Rule 47, it's clear that the rule applies to proceedings where a formal complaint is filed. And so I do believe Rule 47 supports our argument. And so as in Goldman, Your Honors,
So, sorry, I
Go ahead.
just want to make sure I understand. So there would have to be a formal complaint issued by the bar.
there'd have to be a complaint filed with the disciplinary clerk. Yes, Your Honor. And so as in Goldman, Wu's bar charge was dismissed here before the instituting of a proceeding. And like I mentioned, whether dismissed at intake or whether dismissed at screening, there's no substantive difference between either of those two stages because...
The Goldman case analogized it to making a police report. You file a police report, the police look at it, they decide there's nothing here, they close the file and nothing happens. That's not a proceeding.
Correct.
This is, well, and that's what happened in Goldman. The bar charge was filed and the bar closed the file. Here, Mr. Accursio actually had to respond. He was required to participate in convincing the bar counsel not to proceed with the case. So that's different from Goldman, isn't it?
It might be different, but it still doesn't reach the level of a proceeding. Because in Goldman, yes, it was summarily dismissed, but a response could have been asked for. In this case, a response was asked for, but again, it was simply a response. It wasn't a formal answer or a filing with the court. It was a response to the investigator's questions. This was not a response filed in any official court or anything of that nature.
Are you aware of a rule that lets the state bar decide whether to handle an unauthorized practice of law charge under Rule 55 instead of Rule 78?
I am not aware of that rule, Your Honor.
Is there a particular subsection under Rule 47 that spells it out for me, that this is when a proceeding officially begins?
I don't have that written down in front of me, Your Honor. I would have to take a closer look at that rule. But I do believe that in the Goldman case, I believe it's footnote 3, that is where they particularly dive in and describe that a bar charge is very different from a bar complaint, and that bar complaint is what initiates the proceeding. And that's, you know, it's our opinion that this issue has already been decided in Goldman, and like I said, this case is just not much different from the Goldman case. And if there are no further questions, that's all I have, Your Honors.
Thank you.
Thank you.
Your Honors, I do have a few additional comments to make, and especially regarding the position by appellees, is that it has to proceed to a formal complaint being filed. So Mr. Accursio, in order to have a claim against them, would have had to refuse to participate, and then been subject to a complaint, and then he could have a wrongful institution of civil proceeding. So we're in some way, not saying that everyone would do that, incentivizing not participating in the initial process in order to be able to bring a claim for wrongful institution of civil proceedings. But as I believe is clear under the rules, the subpoena power, the contempt power, the protective order rights, it is a proceeding when you have the right to take those rights that Mr. Accursio has, to recommend that to the board. At that point, when Mr. Accursio could be sanctioned or otherwise subject to discipline for just not participating, it's got to be considered a proceeding at that point.
Was Mr. Wu filing a bar charge? Did that initiate a proceeding under 55 or not? Was that enough or not under 55?
I'm not sure if that would be enough, because that would be the initial 55A screening, where somebody at the bar can just look at it and say, no, dismissed, with a single dismissal letter. But this case went well beyond that, right? Mr. Accursio applied for a protective order and it was granted. And so we went well beyond. He was subject to possible contempt proceedings if he didn't respond, subject to discipline if he didn't participate. And so we went well beyond just that initial intake and the decision by the bar to summarily dismiss it as occurred in Goldman.
Goldman compared the situation it was facing with a police report, making a police report. And we don't want to discourage people from making police reports. We don't want people to be afraid of calling the police for fear they might later get sued. The same situation applies here. We don't want to discourage people from making bar complaints if they believe a lawyer has acted improperly. So shouldn't we interpret the rules and Goldman in a way that provides the maximum protection to people who make complaints to the authorities?
There is obviously some legitimacy to that for sure, but that's what wrongful institution of civil proceedings, it's not just filing a bar charge. It is, well, what were the circumstances? What conduct? Why did you do it? He did it in retaliation, to obtain an advantage, to refuse to provide documents. And so that additional protection will make it so that it's not every single time somebody files a report, a bar charge, they'll be subjected to a claim for wrongful institution of civil proceedings.
How would one know? I mean, because in this situation, how would one know if that was going to proceed beyond the simple filing of the bar charge and then essentially summary dismissal versus
Sure.
either way? It seems like you're still asking a member of the public or a fellow attorney to sort of roll the dice, if you will, in heated litigation. Hey, I'm going to file a bar complaint against you because I feel like you've been unethical. And do I thereby face that? I pretty much, then it's in the bar's hands, whether I potentially am going to be faced with a wrongful institution of civil proceedings suit against me, right?
I can, yes, I think that's a consideration for sure. There is also a footnote that we put in our brief that indicated the court could adopt an English rule of requiring special damages in these types of cases, because that way it would weed out some of those just bare cases. But the other thing is obviously, Your Honors, and I know my time is up here, so just as a last comment, the bar is able to weed those things out in that initial intake process.
Counsel, thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. The court is now adjourned.